Dear colleagues, dear students and cadets, let me introduce myself. My name is Kosяченко K. I am an associate professor of the Department of Civil and Legal Disciplines at the Dnipro State University of Internal Affairs. And I am a candidate of legal sciences. I suggest you to listen a course of lectures on the discipline of financial law, which consists of 4 topics. The first lecture that we will consider today is financial law of Ukraine, concept, subject, and methods of legal regulation. The plan of our lecture consists of 3 questions: concept of financial law, subject of financial law, methods of legal regulation of financial law. So let's begin. First questions is concept of financial law. Financial law covers with its influence the corresponding specific circle of relations. These relations are conditioned by the fact that the state uses such an economic lever as finance to fulfill its tasks and carries out financial activities in connection with this. The financial activity of the state is the implementation by the state and its competent bodies of functions related to the planned formation, distribution, and use of monetary funds, meaning financial resources, for the purpose of implementing the task of socio-economic development, ensuring the defense capability and security of the state. However, the subject of financial law research as a field of law, since and academic discipline is not all financials, but only those relationships in which the state takes a direct part. Financial law is a set of legal norms that regulate public relations in the field of mobilization, distribution, and use the centralized and decentralized financial resources of the state in order to ensure the state's performance of its tasks and functions. Financial law belongs to the field of public law and consists of norms regulation the mobilization, distribution, and spending of funds, as well as designed to contribute to the balance of the state revenues and expenditures. The subject of financial law is a set of homogeneous social relations which are regulated by financial and legal norms and cover the movement, its meaning, formation, distribution, and use of centralized and decentralized public monetary funds. At the same time, I will make a few clarifications regarding the definition of the subject of financial law. First, the subject of the field is exactly social relations. The subject of industry regulation always determines the goals, the directions of influence of legal norms. Secondly, the regulation of social relations, which are the subject of financial law, is influenced by financial and legal norms. And thirdly, public funds are the object of financial and legal influence. In this aspect, it is important to understand that it is not about funds directly as material object, but about regulation the behavior of subject of financial and legal relations in relation to public funds. And the last fourth, it's the subject of financial and legal regulation focuses on ensuring dynamic processes, and financial and legal regulation must ground it financial support for the functioning of the state and its administrative and territorial units. Also, the subject of financial law is characterized by curtain branch features. First, relations that are the subject of financial and legal regulation are formed in the field of public financial activity. Second, the object of regulation is the relationship between the participants regarding the funds of the state and administrative territorial entities. Third, expresses a dynamic nature and it's determined by the movement of public monetary funds. And the last is based on the exclusive role of the state. And the next question of our lecture, third, is methods of legal regulation of financial law. The method of financial law covers a set of legal techniques and methods that influence the behavior of the subject of relations and express the powerful commands of the state. Those, the methods of financial law, is the imperative method. The imperative method of financial and legal regulations affecting both sides of the subject of financial legal relations deprives them of their operational independence. The state authority order contained in the law guarantees the realization of the public financial interest by the both of dominant entity and the obligated entity. The imperative method of financial and legal regulations, being traditional for all branches of public law, is certainly characterized by common features with the methods of administrative or criminal branches law. However, this does not exclude the presence of a number of industry-specific features of methods of financial and legal regulations. It should not be assumed that the application of the imperative method in financial and legal regulations means an absolute limitation in the realization of the rights and obligation of the participant, public suppression of the possibility of realizing and achieving their interests. The method of financial law guarantees the implementation of the regime of freedom in the process of implementation of official orders. A similar possibility is carried out firstly within the bounds of the imperative subject right of the dominant subject, for example, the right to carry out an inspection. Secondly, within the limits of the delegated rights, yes, it is possible to credit the amounts from the sale of property that is the tax lion regime against the tax liability. Thirdly, within the framework of the implementation of specific rights, is the right to grant tax preference or tax credits. Those, the main and particularly the only method of financial and legal regulation is the imperative method. So, our lecture is over today. The next topic of our next lecture is financial and legal norms and financial legal relations. Thank you for attention.